I was standing in my driveway at 7 in the morning, coffee in hand, when I saw the bright yellow backhoe sitting exactly where I had parked it the night before. And that is when I noticed the hot pink violation notice taped to the door of my house in Henderson, Nevada. The paper fluttered in the dry desert wind like some kind of absurd flag, and I already knew this was going to be one of those days that started bad and got worse before it got better. My name is Trevor Thompson, and I had lived in the Sunset Ridge development for exactly 3 years. It was one of those planned communities that popped up outside Las Vegas like mushrooms after rain, complete with beige houses that all looked vaguely similar, manicured lawns that required constant watering in the desert heat, and an HOA that apparently had nothing better to do than make everyone's life miserable. I had bought the property specifically because it was on the edge of the development, backing up to open desert land, and I thought that would give me some breathing room. Turns out I was wrong about that breathing room part. I walked up to my front door and yanked the notice off. The tape pulled away some of the paint, which was just perfect. The letter was printed on official-looking letterhead with the Sunset Ridge HOA logo, complete with a little sunset graphic that someone probably spent way too much time designing in Microsoft Word. "Dear Mr. Thompson," it read, and I could practically hear the passive-aggressive tone through the paper. "It has come to our attention that you are in violation of Section 4.7.2 of the Sunset Ridge Community Guidelines regarding commercial vehicles and heavy equipment. The backhoe currently parked in your driveway constitutes a violation of community standards and must be removed within 48 hours. Failure to comply will result in fines of $500 per day and potential legal action. This is your first and only warning. Sincerely, Patricia Pemberton, HOA President." I read it twice, then looked back at the backhoe. It was a nice machine, a Caterpillar 420F that I had purchased 6 months ago. The paint still gleamed in the morning sun, yellow and black, professional and clean. I had been using it for my side business doing excavation work, and also for a project on my own property that was perfectly legal. Though I doubted Patricia Pemberton and her HOA cronies knew anything about that. I pulled out my phone and dialed my lawyer, Marcus Taylor. He was an old friend from high school who had gone into property law and had helped me with the purchase of my house. He answered on the third ring, sounding way too chipper for 7 in the morning. "Trevor, my man, what's up? I need you to pull out the documents from when I bought my house. Specifically, the mineral rights documentation and the surveys." There was a pause. "The HOA is messing with you, aren't they? Bright pink notice on my door. They want my backhoe gone in 48 hours or they are hitting me with $500 daily fines." Marcus laughed, that deep belly laugh that made him sound like Santa Claus, even though he was only 35. "Oh man, they have no idea what they just walked into, do they? Not a clue. Can you get me those documents by this afternoon? Already pulling up your file. I will have everything ready for you by noon. You want me to draft a response?" "Not yet. Let them make the first move. I want to see how far they are willing to take this before I show them what they are dealing with." We hung up, and I finished my coffee while staring at the backhoe. The thing was, I had every right to have that machine on my property. More than that, I had rights that superseded anything the HOA could throw at me. When I bought this property, I had done my homework. The land my house sat on had been part of an old mining claim from the 1980s, back when everyone thought there might be gold or silver deposits in this part of Nevada. The claim had lapsed, but the mineral rights had been separated from the surface rights in a complicated series of transactions. I had purchased not just the house and the land, but also the mineral rights that went with it, which was unusual in modern developments. The previous owner had been a rockhound who had held onto those rights through several property transfers, and when he died, his estate had sold everything as a package deal. Most people would not have cared about mineral rights in a suburban development, but I knew they might come in handy someday. Turns out someday was today. The mineral rights meant that I had the legal authority to conduct mining operations on my property, and that included keeping any equipment necessary for those operations. It was a federal right that predated any HOA rules or local ordinances, backed up by the mining law of 1872 as amended. The HOA could complain all they wanted, but they could not do a thing about it. I spent the morning working from home. I ran a small construction consulting business, which gave me flexibility with my schedule. Around 10, I heard the doorbell ring. When I opened it, I found Patricia Pemberton herself standing on my doorstep, flanked by two other women I recognized from HOA meetings. Patricia was exactly what you would picture when someone says, HOA president. She was in her late 40s with a blonde bob that looked like it had been set with concrete, wearing a white pantsuit, despite the Nevada heat, and carrying a leather folio that probably contained more violation notices. Mr. Thompson, she said, not bothering with pleasantries. I am here to discuss your violation. Patricia. Ladies. What can I do for you? The woman to her left, a redhead named Deborah who served as HOA treasurer, frowned at my casual tone. The one on the right, Susan something, just stared at the backhoe like it had personally offended her. You received our notice, Patricia said. It was not a question. I did. Nice shade of pink, her lips thinned. This is not a joke, Mr. Thompson. That machine is an eyesore and a violation of community standards. We have property values to maintain. It is a backhoe. It is clean, it is well maintained, and it is parked on my property. It is commercial equipment. Section 4.7.2 is very clear. No commercial vehicles or heavy equipment may be stored in plain view of the street. You need to keep it in your garage or remove it from the property entirely. I leaned against the doorframe. My garage is full, and I need the backhoe accessible for my current project. What project? Susan piped up. She had a shrill voice that could probably shatter glass. That is my business, Susan. Patricia's face was starting to turn red, which matched her lipstick in an unfortunate way. Mr. Thompson, I did not come here to argue. The rules are the rules. If you do not comply within the deadline, we will be forced to take legal action. We can place a lien on your property. We can take you to court. We can make your life very difficult. You can try, I said calmly, but I would suggest you consult with the HOA's lawyer before you go down that road. We have already consulted with our attorney, Deborah said smugly. He assured us that our position is sound. You signed the HOA agreement when you purchased this property. You are bound by the rules. Did your attorney look into all the specifics of my property deed? Patricia waved a hand dismissively. We do not need to. The rules apply to everyone equally. That is the point of an HOA. Now, will you remove the machine or not? Not. The three women stared at me like I had just spoken in tongues. Susan actually gasped, putting a hand to her chest like she was having vapors. Patricia's face went from red to purple. Then you leave us no choice, Patricia said coldly. You will be receiving formal legal documents within the week. I suggest you find a good attorney, Mr. Thompson. This HOA does not lose. They turned and marched back down my walkway in formation, like some kind of suburban army. I watched them pile into Patricia's white Mercedes SUV and drive off, probably headed to ruin someone else's morning. I closed the door and went back to work, but I kept my phone close. This was going to escalate, and I wanted to be ready. Marcus showed up around noon with a banker's box full of documents. He spread them out on my kitchen table, grinning like a kid on Christmas morning. Okay, so here is what we have got. Your deed includes explicit mineral rights for this parcel, which is designated as Lot 47, Block 8 of the Sunset Ridge development. The mineral rights were never transferred to the developer, which is super unusual. Normally, developers secure all subsurface rights before they start building, but whoever sold this land to them either kept the rights, or they just did not bother to check. He pulled out a survey map marked with boundaries and elevations. The surveys show that your property sits on what used to be the edge of the old Silver Creek mining district. There were several active claims here in the 80s. Nothing major was ever found, but the claims were filed properly and the rights were maintained. And those rights supersede HOA regulations, I said. Absolutely. Federal mining law trumps local covenants and restrictions. The mining law of 1872, as amended, gives you the right to use your property for mining purposes, and that includes keeping necessary equipment on site. The HOA agreement you signed cannot override federal law. It is not even close. I picked up one of the documents, an official-looking certificate with an embossed seal. So when they try to fine me or put a lien on my property, they are going to run face first into a federal statute that has been upheld by the Supreme Court multiple times. It is going to be beautiful, Trevor. Absolutely beautiful. Marcus helped me organize the documents into a folder, creating a clear chain of title for the mineral rights from the original claim through to my current ownership. We also printed out relevant sections of federal mining law and several case precedents where mineral rights had been upheld against HOA regulations and local ordinances. By the time he left, I had everything I needed to defend my position. The next few days were quiet, which should have been my first warning. Patricia and her gang were not the type to back down quietly. On Thursday morning, I found another notice, this time tucked under my windshield wiper. This one informed me that I was now being fined $500 per day for non-compliance, starting immediately. The fines would be added to my HOA dues and would become a lien on my property if not paid within 30 days. I took a picture of the notice and texted it to Marcus. He responded with a laughing emoji and let them dig their hole deeper. On Friday, I got a certified letter from the HOA's law firm, Whitmore and Associates. It was full of legal jargon, but the gist was clear. Remove the backhoe or face legal action. They demanded compliance within 7 days and threatened to pursue all available remedies, including forcing the sale of my property to satisfy the fines and legal fees. I called Marcus again. They just sent me a nastogram from their lawyers, Whitmore and Associates. You know them. Oh yeah. Richard Whitmore is an ambulance chaser who branched out into HOA law because it is steady money. He is not terrible, but he is not great either. More importantly, he is lazy. He probably did not do any real research on your property. He just took the HOA's word that they had a solid case. Should I respond? Nope. Let them file. Once they actually take you to court, that is when we hit them with the mineral rights documentation. The judge is going to tear them apart and it will be on the record. Trust me, this is going to be fun. I was not sure I shared Marcus's definition of fun, but I trusted his judgment. I spent the weekend working on my actual project, which was drilling some test wells on my property. The mineral rights were not just for show. I had reason to believe there might be a decent aquifer under my land, and if I could tap into it, I would have a private water source that would be worth a fortune in Nevada. Water rights in the desert were serious business. I used the backhoe to dig exploratory trenches, following the survey maps and some geological data I had purchased. The machine's engine echoed across the quiet development, and I could see curtains twitching in windows as my neighbors watched. I gave them a friendly wave. Several of them waved back. Most people in the neighborhood were decent folks who just wanted to live their lives. It was only Patricia and her inner circle who seemed to care about enforcing every petty rule in the HOA handbook. On Monday morning, I found out just how serious Patricia was taking this. I was sitting in my home office when I heard a truck pull up outside. When I looked out the window, I saw a flatbed tow truck in my driveway, and Patricia was standing next to it, pointing at my backhoe. The driver, a big guy in a stained shirt and work boots, was shaking his head. I went outside fast. "What the hell is going on?" Patricia turned to me with a triumphant smile. "Mr. Thompson, since you have refused to remove this violation, the HOA is exercising its right to remove it for you. The cost will be added to your fines. You cannot just take my equipment. According to Section 9.3 of the HOA agreement, we can remove any items that constitute a violation after proper notice has been given. You had your notice. Now we are taking action." The tow truck driver held up his hands. "Look, man, I am just here because she paid me to haul something away. I do not want any trouble." I looked at him. "If you touch that backhoe, I am calling the police and reporting it as theft. That machine is worth $70,000 and you will be an accessory." The driver's eyes widened. He looked at Patricia, who was turning red again. "You did not say it was worth that much, lady. You said it was a code violation." "It is a code violation. Mr. Thompson is exaggerating. It is probably worth half that at most." I pulled out my phone and showed the driver the purchase receipt and registration. "Caterpillar 420F, purchased new 6 months ago. $72,000, fully paid for and registered in my name. If you take it, you are stealing it and I will prosecute." The driver backed up like I was contagious. "Yeah, I am out. Lady, you want to seize somebody's $70,000 equipment, you get a court order. I am not touching this." He climbed back into his truck and drove off, leaving Patricia standing in my driveway looking like she wanted to explode. Her face had gone past red into a shade that was almost maroon. I had never seen someone look so angry while wearing pearls. "You are making this much worse for yourself," she hissed. "The HOA will not tolerate this defiance. We will bury you in legal fees." "Patricia, I am trying to be polite here, but you need to back off. You do not have the authority to seize my property, and if you try again, I am going to file harassment charges. Now get off my driveway." She opened her mouth, closed it, then spun on her heel and stalked back to her Mercedes. She nearly burned rubber pulling out of my driveway, and I heard her engine roar as she sped through the development, probably going at least 20 miles over the speed limit. The irony of the HOA president breaking traffic rules was not lost on me. I called Marcus and told him what happened. He was furious. "They tried to seize your equipment without a court order. Trevor, that is theft, plain and simple. I am drafting a cease and desist letter right now. This needs to go to Patricia, the HOA board, and their attorney. If they try that again, we are going after them for harassment and attempted theft. Do it. I am done being nice about this." The cease and desist letter went out that afternoon via certified mail and email. Marcus did not pull any punches. He outlined the attempted seizure, cited the relevant laws Patricia had violated, and warned that any further attempts to remove my property or harass me would result in immediate legal action, including potential criminal charges. He also included a brief mention of the mineral rights, just enough to hint that the HOA's legal position was not as solid as they thought. That letter must have lit a fire under someone, because 2 days later, I received notice that the HOA was filing suit against me in Clark County District Court. They were asking for an injunction to force removal of the backhoe, enforcement of the fines they had been accumulating, and reimbursement of their legal fees. The filing claimed I was in breach of the HOA agreement and that my refusal to comply was damaging property values and disrupting the peaceful enjoyment of other residents. Marcus called me as soon as he received his copy of the filing. They actually did it. They filed. Trevor, this is perfect. We are going to demolish them in court. How long until we get a hearing? Probably 4 to 6 weeks for the injunction hearing. In the meantime, they cannot touch your backhoe or your property. Once they filed suit, any self-help remedies are off the table. They have to wait for a court order. Good. That gives me time to finish my test drilling. Just keep documenting everything. Take pictures, keep records of when you are using the equipment and why. The more evidence we have that this is legitimate mining activity, the stronger our position. Over the next few weeks, I continued my drilling project while the legal case built up steam. I found some interesting geological formations that suggested my aquifer theory might be correct, which was exciting. I also got to know some of my neighbors better as they stopped by to ask what I was doing. Most of them thought the whole HOA situation was ridiculous, and several offered to testify on my behalf if needed. One neighbor, an older gentleman named George who lived 3 houses down, had particularly strong feelings about it. He stopped by one Saturday while I was working with the backhoe. Trevor, I just want you to know that most of us think Patricia is out of control. She fined me $300 last year because my grass was a 1/4 inch too tall. A 1/4 inch. I measured it myself after she complained. The woman walks around with a ruler. I appreciate that, George. It helps to know I am not the only one who thinks this is crazy. If you need character witnesses or anything for court, you let me know. Half the neighborhood would show up to speak against that woman and her little gang. She acts like she owns the whole development. The hearing was scheduled for a Thursday morning in early March. Marcus and I showed up at the Clark County Courthouse dressed in suits, carrying our box of documents. Patricia was there with Richard Whitmore, her attorney, and she looked confident. Too confident. She clearly thought this was going to be a slam dunk. The judge was the Honorable Margaret Chen, a no-nonsense woman in her 60s who had a reputation for being fair but tough. She did not tolerate games in her courtroom, which worked in our favor since we had the facts on our side. The courtroom was small, one of the standard hearing rooms used for civil matters, with wood paneling and fluorescent lights that hummed slightly. Judge Chen called the case, and we all took our seats. Whitmore stood up to present the HOA's case first. He was a balding man in his 50s with a slight paunch and a tan that looked like it came from a bottle. His voice had that practiced courtroom cadence that some lawyers develop. Your Honor, this is a straightforward case of HOA rule enforcement. The defendant, Mr. Thompson, has violated the clear terms of the community agreement by keeping a large commercial backhoe in his driveway in plain view of the street. Section 4.7.2 of the Sunset Ridge HOA guidelines explicitly prohibits commercial vehicles and heavy equipment. Mr. Thompson was given notice and opportunities to comply, but has refused. The HOA is seeking an injunction to force removal of the equipment and enforcement of the fines that have accumulated due to his continued non-compliance. He presented the HOA agreement I had signed at closing, with the relevant section highlighted. He also presented photos of my backhoe taken from the street, emphasizing how visible it was. He submitted statements from Patricia and other board members about how my violation was affecting property values and resident satisfaction. Judge Chen listened patiently, reviewing the documents. Then she looked at me. Mr. Thompson, What is your response to these allegations? Marcus stood. Your Honor, if I may, I am Marcus Taylor, representing Mr. Thompson. While it is true that the HOA agreement contains the sections cited by opposing counsel, that section is superseded by federal law. Mr. Thompson owns not just the surface rights to his property, but also the mineral rights, which he is actively exercising. Federal mining law gives him the right to keep necessary equipment on his property for mining purposes, and that right cannot be restricted by an HOA agreement or local ordinance. The courtroom got very quiet. I could see Whitmore frown and flip through his papers like he was looking for something he had missed. Patricia's confident expression faltered. Judge Chen leaned forward. You are claiming active mining rights. Yes, Your Honor, we have complete documentation. Marcus opened our box and started pulling out documents. Chain of title for the mineral rights, going back to the original mining claim filed in 1984. Transfer of those rights through several owners, culminating in Mr. Thompson's purchase in 2022. We have surveys showing the property boundaries, geological surveys Mr. Thompson commissioned, and records of his test drilling activities. He handed a stack of documents to the bailiff, who passed them to Judge Chen. She spent several minutes reviewing them, her expression neutral but focused. Whitmore was whispering urgently with Patricia, who looked like she was in shock. Your Honor, Whitmore said, standing up, we were not aware of any mining rights claims. This was not disclosed during our investigation. Perhaps you should have investigated more thoroughly, Judge Chen said dryly. She looked at Marcus. Counsel, do you have case law supporting your position? Extensive case law, Your Honor. Marcus pulled out another stack of papers. The most relevant is Granite Rock Company v. California Coastal Commission, where the Supreme Court affirmed that federal mining law supersedes state and local regulation. Also SCA v. United States, which specifically addressed HOA restrictions. In every case, the courts have held that valid mineral rights under federal law cannot be restricted by covenant agreements or local rules. Judge Chen reviewed the cases, nodding slightly as she read. The silence in the courtroom was deafening. I could see Patricia's hands clenching and unclenching on the table in front of her. Whitmore looked like he wanted to disappear. Finally, Judge Chen looked up. She fixed Whitmore with a stare that could have melted steel. Mr. Whitmore, did you conduct any title search or property research before filing this action? We reviewed the HOA agreement and the general property records, Your Honor. But you did not look into mineral rights or easements. The HOA did not inform us that mineral rights were an issue. Judge Chen turned her gaze to Patricia. Miss Pemberton, did you research Mr. Thompson's property rights before attempting to enforce this violation? Patricia stood up, smoothing her skirt. Your Honor, we were enforcing the rules that all residents agreed to follow. We did not think we needed to research anything beyond the HOA agreement. You did not think, Judge Chen repeated. Her tone could have frozen lava. Miss Pemberton, you attempted to seize a $70,000 piece of equipment without a court order, based on an HOA rule that you did not bother to verify was legally enforceable. Do you understand how serious that is? We were trying to enforce community standards. You were attempting theft. Judge Chen's voice cracked like a whip. Mr. Thompson would have been within his rights to call the police and have you arrested. The only reason you are standing in my courtroom instead of a jail cell is because his attorney advised restraint. Patricia's face went white. Whitmore put a hand on her arm, probably trying to keep her from saying anything else that would make the situation worse. Judge Chen looked back at the documents. Based on the evidence presented, It is clear that Mr. Thompson has valid mineral rights to his property and is exercising those rights in a lawful manner. Federal mining law explicitly permits the keeping of necessary equipment for mining operations, and this right supersedes the HOA agreement. The HOA had no legal basis to issue violations or fines, and certainly no basis to attempt seizure of the equipment. She signed something on her paperwork with decisive strokes. The HOA's request for an injunction is denied. All fines issued to Mr. Thompson are hereby voided. Furthermore, I am ordering the HOA to reimburse Mr. Thompson for any legal fees incurred in defending against this baseless action. Mr. Taylor, please submit an accounting of your fees and costs. Yes, Your Honor. Additionally, Judge Chen continued, and her tone got even more severe, I am sanctioning the HOA and its counsel for bringing a frivolous lawsuit. You filed this action without conducting basic due diligence into the defendant's property rights. That is not just poor lawyering, Mr. Whitmore. It is a waste of this court's time and resources. I am ordering the HOA to pay an additional $5,000 in sanctions to the court. Whitmore looked like he wanted to argue, but he just nodded. Yes, Your Honor. Judge Chen was not done. Miss Pemberton, let me be crystal clear. If you or the HOA attempt any further action against Mr. Thompson related to this backhoe or his mining activities, I will hold you in contempt of court. Mr. Thompson has every legal right to keep that equipment on his property and to use it for its intended purpose. If you harass him, fine him, or attempt to seize his property again, you will face criminal charges. Do you understand me? Yes, Your Honor, Patricia said weakly. Good. This case is dismissed with prejudice. Mr. Thompson, you are free to continue your mining activities without interference. Court is adjourned. The gavel came down with a sharp crack, and it was over. Marcus was grinning like a maniac. I felt a wave of relief wash over me so strong that my knees almost buckled. We gathered up our documents while Patricia and Whitmore huddled in urgent conversation. As we headed for the door, I heard Patricia's voice rise. How could you not know about this? You are supposed to be the lawyer. You are the one who told me it was a simple code violation. You said he was just being stubborn. Their argument faded as we left the courtroom. In the hallway, Marcus clapped me on the shoulder. That went even better than I hoped. Not only did we win, but the judge sanctioned them and ordered fee reimbursement. Trevor, this is a total victory. How much do you think the fees will come to? With all the research and documentation I did, plus today's appearance, probably around $8,000. The HOA has to pay all of it, plus the $5,000 in sanctions. This little crusade just cost them $13,000, not counting what they paid Whitmore. We left the courthouse and celebrated with lunch at a steakhouse downtown. Marcus regaled me with stories of other HOA cases he had handled, though he admitted this was the first time mineral rights had been involved. As we ate, my phone started buzzing with texts. Word had apparently gotten around the neighborhood about the hearing, and people were congratulating me. George sent a message that just said "good," with about 10 exclamation points. A woman named Alice from 2 streets over sent a longer message saying she was thrilled someone had finally stood up to Patricia, and won. Even people I did not know well were reaching out to express support. When I got home that afternoon, my street was quiet. The backhoe sat in my driveway, gleaming yellow in the desert sun, no longer threatened. I stood there for a moment, just looking at it and feeling grateful that I had done my homework when buying the property. Those mineral rights had seemed like a quirky bonus at the time, something interesting but probably not useful. Turns out they had been the key to everything. I spent the evening working on my test well project. I was getting closer to finding the aquifer I suspected was down there, and the drilling was going well. The sound of the backhoe's engine was oddly soothing after all the stress of the past few weeks. This was honest work, productive work, and nobody could tell me to stop. The next morning, I got a formal letter from Whitmore's office with an accounting of the fees the HOA owed me. Marcus's bill came to $8,200, which seemed fair given the amount of work he had put in. The letter was polite and professional, with none of the threatening language from their previous correspondence. It said a check would be issued within 30 days as ordered by the court. I also received a separate letter, this one from the HOA board itself. It was signed by all 5 board members, including Patricia. The tone was stiff and formal, clearly written by a lawyer, but the message was clear. They were backing off. The letter acknowledged the court's ruling, confirmed that all fines had been voided, and stated that I would not be subject to any further violations related to the backhoe or my mining activities. It was as close to an apology as I was going to get from Patricia Pemberton. Life in Sunset Ridge settled into a new normal over the following weeks. Patricia stopped glaring at me when we crossed paths, though she also stopped acknowledging my existence entirely, which was fine by me. The HOA board became noticeably quieter, and I heard through the neighborhood grapevine that several residents had complained about how much the lawsuit had cost in HOA dues. Apparently, the $13,000 in legal fees and sanctions, plus Whitmore's original fees for filing the case, had blown a significant hole in the HOA's budget. There was talk of a special assessment to cover the costs, which was making people angry. Some residents were calling for Patricia to resign as president, saying she had exceeded her authority and wasted everyone's money. I stayed out of that drama. My focus was on my test wells, and I was making real progress. About 6 weeks after the court hearing, I hit water at about 200 feet down. It was not a huge flow, but it was clean and consistent, and testing showed it was good quality. I had found my aquifer. Marcus helped me file the necessary paperwork to establish water rights, which in Nevada was almost as complicated as the mineral rights had been. But we got it done, and suddenly, my property was worth significantly more than when I had bought it. Not only did I have the house and land, but I also had independent water rights in a desert state where water was becoming increasingly valuable. A funny thing happened after that. Other residents started asking me questions about mineral rights and property research. It turned out that several other houses in Sunset Ridge had similar situations where the mineral rights had never been properly transferred to the developer. Most people had no idea, and most of them would never care, but a few saw the same opportunity I had seen. George, my neighbor who had offered to testify for me, actually started doing his own geological surveys. He discovered that his property sat on what might be a geothermal hot spot, something that could potentially be developed for heating. He came over one evening with beers and maps spread out on my patio table, excited as a kid with a new toy. "Trevor, I never would have thought to look into this stuff if not for your case. I just figured the HOA rules were the HOA rules, and that was that. But you showed everyone that there are bigger laws, more important rights. This is my property and I am going to use it the way I want to. Just make sure you document everything," I advised. "Get good legal help up front. Marcus is great if you need a referral. Already called him." We are meeting next week. The summer passed quietly. I continued to use my backhoe for various projects, including helping George with his initial geothermal surveys. The machine sat in my driveway whenever I was not actively using it, a big yellow reminder that sometimes standing up for your rights actually works. Patricia and the HOA board left me alone, and I left them alone. It was a peaceful stalemate. In August, something unexpected happened. I came home from a consulting job to find an official-looking car parked in front of my house. Two people in business casual clothes were standing on my porch, and they did not look like HOA representatives. The man was tall and lean with graying hair, and the woman was younger with dark hair pulled back in a ponytail. They both had that professional demeanor of people who are used to being taken seriously. "Mr. Thompson," the man said as I approached. "My name is David Morrison, and this is Jennifer Garcia. We are with the Nevada Division of Minerals. Do you have a few minutes to talk?" My first instinct was worry, wondering if I had done something wrong with my mining activities or water rights. But their expressions were friendly, not confrontational. I invited them inside and offered coffee, which they accepted. We sat in my living room, and David pulled out a tablet computer. "Mr. Thompson, we became aware of your property through the court case earlier this year. One of our analysts saw the filing and flagged it because mineral rights cases are relatively rare in residential developments. We have been reviewing the geological data for this area, and we think there might be something interesting going on." "Interesting how?" I asked. Jennifer tapped on the tablet and brought up a geological map. The old Silver Creek mining district was never fully explored. The prospectors in the 80s were looking for gold and silver, and when they did not find commercial quantities, they gave up. But modern analysis suggests there might be significant deposits of lithium and rare earth elements in this area. Those minerals are extremely valuable now because of electric vehicle batteries and electronics. I stared at the map, seeing my property highlighted in yellow. "You think there is lithium under my house?" "Possibly. The geological formations are right, and there are some indicators from old core samples. We would need to do more extensive testing to know for sure, but your property is in a prime location. The reason we are here is to ask if you would be willing to allow some survey work. If there is something valuable, it could be very beneficial for you and for the state." "What kind of survey work are we talking about?" David explained that they wanted to do electromagnetic surveys and possibly some additional core drilling. It would not damage my property, and any findings would belong to me as the mineral rights holder. The state was interested because developing rare earth mining in Nevada could be economically significant, and they wanted to map the potential resources. I told them I needed to consult with my attorney before agreeing to anything, which they understood. They left me with contact information and some preliminary geological reports. After they left, I called Marcus immediately. "The Division of Minerals wants to survey my property for lithium. Trevor, you understand what this could mean. If there are commercial quantities of lithium or rare earth elements under your land, you could be looking at royalties that would make you wealthy. Not comfortable, wealthy. Is there a catch? There is always a catch. You need to make sure any agreement you sign protects your rights and gives you fair compensation. But this is potentially huge. I can review whatever they propose and make sure you are protected." Over the next few weeks, Marcus negotiated an agreement with the Division of Minerals. They would conduct surveys at their expense, and any data they collected would be shared with me. If commercial deposits were found, I retained all rights to develop them or license them as I saw fit. It was a good deal, and I signed off on it in September. The survey crews showed up in October, and suddenly, my quiet suburban property became a hub of geological activity. They brought specialized equipment and set up a temporary office in my garage. The backhoe that had caused so much trouble actually proved useful for the survey work, and I helped them dig access holes for their instruments. My neighbors watched all this with fascination. George joked that Sunset Ridge was turning into a mining town. Patricia and the HOA board stayed silent, which I took as a sign that they had learned their lesson. The court's warning about contempt charges had apparently stuck. The preliminary results came back in November, and they were stunning. The surveyors found significant lithium deposits starting at about 400 feet down, in quantities that could potentially be commercially viable. The rare earth elements were less certain, but there were definitely promising indicators. David Morrison called me personally to share the results. "Mr. Thompson, congratulations. You are sitting on something valuable. Now, developing these deposits would require significant investment and permitting, and it might not happen quickly. But you have options. You could partner with a mining company, you could license the extraction rights, or you could just sit on them and wait for lithium prices to go up. Either way, you have an asset that is worth serious money." I thanked him and hung up, then sat in my kitchen for a long time just processing the news. I had bought this house 3 years ago thinking I was getting a decent property in a good location. I had fought the HOA over a backhoe because I knew I had the legal right to keep it. And now it turned out that my stubborn insistence on my mineral rights had revealed resources that could change my life. Marcus helped me field inquiries from mining companies who had heard about the discovery through industry channels. Several wanted to negotiate licensing agreements or partnerships. I was not in a hurry to decide, though. The lithium was not going anywhere, and I wanted to understand all my options before committing to anything. December brought an unexpected development. The HOA held its annual meeting, which I normally skipped because they were boring and contentious. But this year, several neighbors convinced me to attend because there was going to be a vote on the board composition. Apparently, a group of residents had organized to challenge Patricia and her allies, and they wanted me there for moral support. The meeting was held in the community clubhouse, a bland building with a meeting room that smelled like old carpet and air freshener. About 60 residents showed up, which was apparently a record turnout. Patricia sat at a table in front with the other board members, looking tired and defensive. The mood in the room was tense. The meeting started with standard business, approving minutes and reviewing financial reports. Then came the board elections. Normally, the existing board members just ran unopposed and were automatically re-elected. But this year, 5 residents had put their names forward as challengers, and they each gave short speeches about wanting to make the HOA more reasonable and less confrontational. George was one of the challengers. His speech was blunt. "I have lived here for 8 years, and I have watched this HOA become more and more focused on petty enforcement and less focused on actually improving our community. The lawsuit against Trevor Thompson was the last straw. We wasted over $20,000 in legal fees and sanctions because our president did not do basic research before trying to seize someone's property. That money should have gone to fixing our pool, improving our landscaping, or reducing our dues. Instead, it went to lawyers because of a personal vendetta. We need new leadership." There was applause. Patricia's face went tight, but she did not respond. The vote was conducted by secret ballot, and while we waited for the counting, people mingled and talked. Several residents came up to me to express support and to ask about the lithium discovery. Word had spread, and people were fascinated. When the results were announced, it was a clean sweep. All 5 challengers won, including George. Patricia and her entire board were out. She stood up without a word and walked out of the meeting, followed by Deborah and Susan. There was a moment of stunned silence. Then someone started clapping, and soon the whole room was applauding. George was elected as the new HOA president, and his first act was to propose a motion to formally apologize to me for the previous board's actions, and to clarify that mining activities and related equipment were explicitly allowed under federal law. The motion passed unanimously among the new board members. After the meeting, George and I went out for drinks with some of the other new board members. They were energized and full of ideas for making the HOA actually useful instead of just punitive. They talked about better communication, reasonable enforcement of rules that actually mattered, and focusing on community improvement rather than nitpicking violations. "Trevor, none of this would have happened if you had not stood up to Patricia," George said, raising his beer. "You showed everyone that the HOA is not all-powerful, that there are limits to what they can do. You inspired people to get involved and make changes, so thank you." "I just wanted to keep my backhoe," I said with a laugh. "Yeah, but you did it the right way. You knew your rights, you documented everything, you got good legal help, and you stood your ground. That is how you win." We toasted to new beginnings, and I felt genuinely good about the neighborhood for the first time since the whole mess started. Sunset Ridge was still a planned community with rules and regulations, but it was going to be run by people who understood that those rules needed to be reasonable, and that residents had rights that superseded HOA authority. As winter settled in, I continued to work with mining companies to explore options for the lithium deposits. I was leaning toward a licensing agreement that would pay me royalties while letting someone else handle the actual extraction and processing. It would provide steady income without requiring me to become a mining operator, which was not really my area of expertise. The backhoe still sat in my driveway, though I used it less frequently now that the initial survey work was done. It had become almost a symbol in the neighborhood, a reminder that standing up for yourself could actually work out. Kids would sometimes stop and stare at it on their way home from school, and I would wave to them from my porch. On Christmas Eve, I got a certified letter that turned out to be the final chapter in the HOA saga. It was from a law firm in Las Vegas that I did not recognize, and when I opened it, I found a settlement offer. Patricia Pemberton was suing the old HOA board members, her own former colleagues, claiming they had pressured her to take aggressive action against me and had failed to properly advise her of the legal risks. She was seeking damages for the harm to her reputation and for emotional distress. Attached to the settlement offer was a request for a statement from me, detailing my interactions with Patricia and the board. The lawyers wanted ammunition to use in the case, and they thought I might be willing to help given how Patricia had treated me. I called Marcus, even though it was Christmas Eve and I felt bad bothering him, but he was home with family and told me to read the letter over the phone. When I finished, he was silent for a moment, then he started laughing. She is suing her own board, the board that she controlled and directed. "Oh man, this is beautiful. Trevor, do you want to get involved in this?" "Not really. I won my case, the bad board is gone, and I am moving on with my life. I do not need to get dragged into Patricia's civil war." "Smart choice. Send the lawyers a polite letter declining to participate. You do not owe Patricia anything, and you do not owe her opponents anything either. Let them fight it out." I followed his advice and sent a brief response saying I had no interest in being involved in the dispute. I heard later through the neighborhood grapevine that Patricia's lawsuit went nowhere. The judge threw it out on some procedural grounds, and she ended up eating even more legal fees. She moved out of Sunset Ridge a few months later, and I never saw her again. The new year brought a final resolution to the mining rights situation. I signed a licensing agreement with a mining company called Western Lithium Resources. They would conduct detailed exploration work, and if commercial extraction proved viable, they would develop the lithium deposits. I would receive royalties based on production, with a guaranteed minimum payment even during the exploration phase. The guaranteed minimum alone was more than I made from my consulting business, and if production actually started, the royalties could be substantial. Marcus reviewed the contract carefully and negotiated several improvements, including provisions to protect my property and ensure the surface rights were not damaged by any underground work. The final agreement was fair and favorable, and I signed it in February with a sense of satisfaction and relief. Standing in my driveway on a cool March morning, exactly 1 year after the court hearing, I looked at the backhoe that had started everything. The yellow paint was a bit more faded now, and it had more dirt and wear from a year of use. But it was still mine, sitting on my property where it belonged. No one could tell me to move it, no one could fine me for having it, and no one could try to seize it without facing serious legal consequences. George walked over with his morning coffee, a routine we had developed over the past few months. He looked at the backhoe and shook his head with a smile. "You know, when Patricia first started going after you about that thing, I thought you were crazy to fight her. The HOA seemed so powerful and she was so aggressive. I figured you would end up losing your house or buried in debt from legal fees." "I thought about giving up a few times," I admitted. "It would have been easier to just park the backhoe somewhere else or sell it. But it was not really about the backhoe. It was about whether I had the right to use my own property the way I wanted to, for legitimate purposes." "And you did have that right." "Yeah, I just had to prove it." We stood there quietly for a moment, watching the sunrise over the desert. Sunset Ridge was waking up around us, people heading to work, kids waiting for school buses. It was a normal suburban morning, peaceful and ordinary. The kind of morning I had wanted when I bought this house. "So what are you going to do if the lithium mining actually happens?" George asked. "Are you going to stay here?" "I think so. I like this house, I like this neighborhood, and now that the HOA is sane again, it is actually a nice place to live. Plus, I have water rights and mineral rights and a backhoe that is legally protected. Why would I leave?" George laughed. "Fair enough. Just remember us little people when you are a lithium millionaire. You are doing okay yourself with that geothermal project. True. Who knew that buying a house in a planned community would turn into a mining operation?" We went back to our respective houses, and I spent the day working on consulting projects and planning my next steps with the lithium exploration. Life had settled into a comfortable routine, but it was a routine that I had fought for and won. Every time I saw that backhoe in my driveway, I was reminded that knowing your rights and standing up for them actually mattered. The Mining Law of 1872, a piece of legislation that was over 150 years old, had protected my property rights against a modern HOA that thought it was untouchable. Federal law had trumped local covenants, exactly as it was supposed to. The legal system had worked the way it was designed to work, even if it took a judge's sharp words to make it clear. In the end, the story was simple. The HOA tried to seize my backhoe for violations. They tried to fine me, intimidate me, and force me to comply with rules that did not apply. But when I showed the judge my mining rights, those rules meant nothing. The law was on my side, and that made all the difference. Patricia Pemberton learned a hard lesson about overreach and the importance of doing your homework before picking a fight. The HOA learned that residents have rights that cannot be taken away by covenants and guidelines. And I learned that sometimes, buying mineral rights that seem like a quirky bonus can turn out to be the best decision you ever made. I kept using my backhoe for various projects around my property, and it remained a fixture in my driveway, visible from the street. Nobody complained. The new HOA board had better things to worry about, like fixing the pool and organizing community events. They did their job of maintaining common areas and enforcing reasonable rules, but they did not waste time on petty violations or personal vendettas. As spring turned to summer, Western Lithium Resources began their detailed exploration work. They drilled several test wells and ran extensive analysis on the mineral deposits. The preliminary results continued to be promising, and they started talking about timelines for actual production, though that was still years away. In the meantime, my guaranteed minimum payments provided a nice supplemental income that let me be more selective about consulting work. I even ended up helping a few other homeowners in similar situations around Nevada. Word spread about my case, and people started reaching out when they had HOA disputes involving property rights. I was not a lawyer and could not give legal advice, but I could share my experience and refer them to Marcus, who was building quite a practice in property rights law. One case in particular stood out. A woman in Reno named Sandra Lincoln had a similar situation with an HOA trying to stop her from keeping beehives on her property. She had agricultural rights that predated the HOA, and using my case as a template, Marcus helped her win in court. The judge ruled that her agricultural activities were protected, and the HOA had to back down. Sandra sent me a jar of honey with a note that said, "Thank you for fighting first." That note sat on my kitchen counter for weeks, and every time I saw it, I felt good about what had happened. Fighting the HOA had been stressful and expensive, even though I ended up getting reimbursed. But it had also been worth it, not just for me but for other people who found themselves in similar situations. The backhoe eventually did get some company in my driveway. I bought a small excavator for more detailed work and a trailer to transport equipment when needed. The new HOA board approved my request without any issues, recognizing that my mining activities were legitimate business. George joked that I was turning my property into a construction yard, but he said it with a smile. By the fall, Western Lithium Resources confirmed that the lithium deposits were commercially viable and announced plans to begin permitting for extraction operations. The process would take several years to navigate environmental reviews and regulatory approvals, but it was happening. My property was going to be part of a mining operation that could supply materials for electric vehicle batteries for decades to come. A reporter from the Las Vegas Review-Journal did a feature story about the whole situation, from the HOA dispute through the lithium discovery. The article portrayed me as a regular guy who stood up for his rights and ended up making a significant mineral discovery. It was mostly accurate, though they made it sound more dramatic than it felt at the time. The article did mention Patricia by name, detailing the attempted seizure and the court's rebuke, which probably did not make her happy. But that was her own doing. As the year wound down, I reflected on everything that had happened since that morning when I found the bright pink violation notice on my door. I had been angry and frustrated then, convinced the HOA was going to make my life miserable, and they tried. But because I had done my homework when buying the property, because I knew my rights, and because I had good legal help, I won. The backhoe sat in my driveway as the first snow of winter dusted the desert, a yellow beacon of property rights and personal determination. It was just a machine, a tool for digging and moving earth. But it had become something more, a symbol of what happens when you stand your ground for the right reasons. I never regretted fighting the HOA, even in the stressful middle of the dispute when the outcome was uncertain. Some fights are worth having, not because you want conflict, but because the alternative is giving up your rights. Patricia and her board thought they could bully me into compliance, that I would be too intimidated or too tired to resist. They were wrong. The judge laughed, or at least smiled with satisfaction, when I showed those mining rights in court. The law was clear, the precedents were solid, and the HOA never had a chance. They just did not know it until they were standing in front of Judge Chen being lectured about federal law and threatened with contempt charges. Looking back, I was grateful for every part of the experience, even the difficult parts. I was grateful for Marcus and his expertise. I was grateful for neighbors like George who offered support. I was grateful for a legal system that, despite its flaws, ultimately protected property rights over HOA overreach. And I was grateful for that old rockhound who held onto the mineral rights through multiple property transfers, making it possible for me to purchase them as a package deal. The backhoe would probably stay in my driveway for years to come, ready for whatever projects I needed it for. It would sit there through summer heat and winter cold, through HOA meetings and neighborhood barbecues, a reminder that knowing your rights and standing up for them makes all the difference. And if anyone ever asked me about it, I would tell them the story of how an HOA tried to seize my backhoe for violations, and how the judge responded when I showed them my mining rights. It was a good story, a true story, and one I was proud to tell.